Broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to the Micklin Law Group's monthly webinar series. We will get to the webinar in just a minute. All right, welcome and let's begin. Today's webinar is 4 Steps to Smart Co-Parenting, Essential Tips for Divorced Dads in New Jersey. As you know, divorce can be a challenging time, but co-parenting effectively is crucial for your children's well-being. As a divorced dad in New Jersey, these 4 steps can help you navigate this journey and foster a positive co-parenting relationship. And if you stay through the entire webinar, you may find a couple extra bonus tips I'm going to throw in for you. So let's begin. For those that have not worked with me in the past, my name is Brad Micklin. This is me. Well, this is me probably about 2 years ago, but hopefully I don't look much different. I am the lead attorney and managing member of the Micklin Law Group. We are a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Saddlebrook, and Montclair, New Jersey. You will see a QR code, which if you click onto that through your camera will lead you to my online calendar scheduling. You can book a consultation with me now or in the future. You will be contacted thereafter by a staff member to complete an intake, which will then confirm the meeting, but you can get onto my calendar quickly and schedule time if you would like to speak to me about something. I have and continue to serve as a legal correspondent and analyst. I've been honored to appear on Fox News, Inside Edition, Larry King Show, Super Great Guy, may he rest in peace, I-24 International News, and many others. I say this not to impress you, but to impress upon you the experience that I bring to your matter and to my practice. Next, you'll see a series of awards I've been honored to receive, both from colleagues and from clients. I have actually received, thankfully, many more that you can see on my website at micklinlawgroup.com. But here's a few. Again, these are here not for impressions, but to impress upon you what I think I've done for people, how I think I have served them, and how I hope to continue to do so in my future. All right, so let's talk about step 1. Establish clear communication with your ex-spouse. Now, this webinar is for divorced fathers. It will still largely apply if you were not married, but being a divorce practitioner, there are some unique differences, so we did tailor it to that need. So first, set ground rules. Agree on communication boundaries and the best way to discuss parenting decisions. 2, be respectful. Even though your relationship has changed, maintain a civil and cooperative tone is essential. Focus on your children. Keep the conversation centered on your children's need, not personal grievances or past issues. And document discussions in New Jersey. Now, you can document all your discussions anywhere, but as I say here, keep a recording of important conversations and decisions to avoid misunderstandings. Important caveat, if you are recording, you can record a person in New Jersey without his or her consent, but other states are different. So if you're going to be recording somebody in another state, check with either the internet to see if you can get an answer, or a much better choice is contact an attorney to make sure that you can make a recording out of your jurisdiction. Now, I say keep it respectful first because it's obviously going to help you co-parent. It's going to be better long-term in your relationships, both with your ex-spouse and children. But especially if it's going to be in a recording, in a voicemail, or in a text or email. Always, always, always leave messages and write messages as if a judge is going to be reading them in the future. It is very likely that if you're watching this webinar, you will have a judge in your future reading these messages. You never, ever want to say or do anything that's going to compromise your position, make you look unreasonable, or expose you to a possible restraining order, which is beyond the scope of this webinar, but you can go to my website, micklinlawgroup.com, MICKLINLAWGROUP.com, or my YouTube page, Brad Michael Micklin, for webinars on restraining orders, how to obtain one, how to defend against a bogus one, and many others. Secondly, keep the communications respectful, because in many cases and many occasions, your children will be present during these conversations, during these communications, and you may not even be aware of it. If we have a recording or a voicemail that's being played on speakerphone, messages that are being printed out, left on the table, there are many reasons why your children may overhear conversations. They just live in the house. They're going to hear mom or dad on the phone. You don't want them to hear you being disrespectful to the parent. They will grow to possibly resent you for it. Excuse me. Step 2, develop a consistent and structured parenting plan. First, custody arrangements. Establish a clear schedule for visitation, parenting time, as we actually call it. I should have changed that. Parenting time and custody that prioritize your children's needs. 2, agree on consistent discipline rules, consequences, and disciplinary approach to maintain stability in both households. And 3, extracurricular activities. Always coordinate your children's schedules and commitments to ensure that they feel supported, because in many cases, they may conflict with your exercising of parenting time. You may have to sacrifice your time for their activities. I say this as step 2 because a lot of people don't take into consideration the fact that your children are going to grow up. They're going to become boyfriend, girlfriends, fiancés, spouses, parents. Their views on what happened in their childhood or what happened between their parents will change as they pass through these different phases of their own lives, and they will start to see things differently. You don't want them to see you differently. Additionally, when you have a custody arrangement, always reduce it to writing. If you have a court order, now that is in writing, but if you're going to change that agreement in any way, you also want that to be in writing. A lot of people think that they can agree to change, and by conduct they're going to change, or if they've changed something, the other spouse has gone along with it for some period of time, that will hold up in court as a modification. It may not. If, for instance, you've acquiesced or your spouse has acquiesced to a change in your schedule, giving you more time for a period of time, and then decided one day to take it back, you're going to lose it. Now, there may be arguments, if it's been for a considerable period of time, that it should continue because of fairness. If it's impacting the children by changing it, it may continue. But generally speaking, if it's in writing, it will stay on that schedule. That schedule is the only one that can be enforced through the court. So you want to make sure that any change is put in writing, even if it's an email, just confirming what you agreed to. It doesn't necessarily need to be printed and notarized and signed. While that is preferable, it can be just an email saying, hey, let this confirm, we agreed to change this, and it's going to become that. The absence of a response or a rejection or a denial is often very persuasive, if not binding, for the change. Number 3, prioritize your children's emotional well-being. 1, minimize conflict where possible. Avoid exposing your children to parental disputes and keep disagreements away from them, as I mentioned before. 2, provide reassurance. Reassure your children that the divorce is not their fault and that you do love them and it has nothing to do with them. 3, encourage open communication. Create a safe space for your children to express their feelings and concerns. Do not encourage them to speak badly about the other parent. You shouldn't speak badly about the other parent to them. That's not what is meant by encouraging open communication, unless it happens to be their natural communication. Along with prioritizing their emotional well-being, they may have needs that are beyond your scope. You may want to look into therapy. You might want to look into counselors. Many other support processes are available, so, other resources through the schools, through governmental organizations and entities, philanthropic. There are an ever-increasing amount of resources, especially to assist children through the difficult dynamics of a divorce. If you think your children would benefit, and most do, from some help, you certainly should investigate it. Now, I'm not one that necessarily suggests that every child should be in therapy because of divorce. I think it can be disempowering sometimes to tell a child they're having difficulty, they need therapy. Sometimes the children believe it's their inability to cope that they need the therapy for, and sometimes you're reinforcing a bad view. But these issues are certainly far beyond my capabilities. So generally speaking, investigate the options, interview some people, bring your children to some people, and see what's going to be best for them. One additional caveat: if you are going to take your children to a therapist or to a counselor, you should let the other parent know, get the other parent's consent, include them in the meetings and in the schedules, or at least tell them when and where they're going to be. Allow them the opportunity to attend and appear. Whether they exercise and utilize that or not is on them, but it's certainly always good to show that you had them engaged in the conversation before moving forward and engaging your children in professionals. And you want to do that also because, you want to be able to continue. If you take your children to a therapist and the other parent didn't know about it and objects, that may conflict the therapist out. Now the emotional support that your children have been receiving is now removed. Now you're in a battle of whether or not it's in their best interest to keep it or not. And it's just an issue that you want to avoid if you can, when avoiding it simply by just advising the other parent of your intentions. Number 4, manage conflicts and disagreements effectively. 1, identify the issue. Clearly define the problem and understand each other's perspective, not just your own. 2, seek a compromise, which may be difficult. Explore solutions that address both your needs and your children's best interest. And 3, use mediation if necessary. Consider professional mediation to resolve conflicts in a constructive manner. Now, additionally, partly if you're going to have conflicts and disagreements and address these issues, whether it's in mediation or not, again, any agreement that you reach should be in writing, even if it's in or through mediation. And this is very important in New Jersey family law. No agreement reached, whether it be in mediation or in other forms, no agreement is binding unless signed by the two parties. That means that you can spend hours upon hours upon hours in mediation, of which you may be paying a lot of money for, with attorneys, or both, that you're paying a lot of money for. You can even spend time and money to have the agreement written up and not be signed. You could also start living under the terms of the agreement and abiding by it, and yet none of it is legally enforceable if it has not been signed by both parents. Now, I generally recommend, if you're going to be entering into an agreement, especially in mediation or where you're actually expending a lot of time and money, that you do reduce it to writing at that very session, even if it's just what we call a term sheet, which is simply identifying the terms and signing a piece of paper. It can be electronically signed. You could possibly try to send emails back and forth if you're doing the session virtually. But generally speaking, you do want to have it signed. Now, one exception or one consideration is that cuts both ways, because you may leave mediation and decide you don't like the agreement that you reached, and you may want to just end it, terminate it, eliminate it. And if you signed it, you can't do that. So by signing it, you're losing that opportunity to sleep on it. Conversely, so is the other person. So while you may be preserving your right to tank the agreement by not signing it, you're also investing that right in the other party to tank it the next day if they want to sleep on it. So all in all, I generally recommend signing the agreement, even if it binds you to an agreement that you later find less than favorable, because at least you have something to work from. You can use this in other videos that I have and we'll discuss later if you need to change that agreement, but having an agreement in writing is far better than operating without. Additionally, New Jersey does now allow binding arbitration for custody disputes. You couldn't always do that But there are cases now that have authorized arbiters to make custody decisions when the parents agree to it. There are advantages to mediation and arbitration. Mediation is less formal and not binding unless you agree, and again, as I said, and sign the agreement. Arbitration is generally going to be a binding agreement presented through discussions with a third party of your choice, usually an attorney or retired judge. Arbitration, again, is good and less formal than trial. It's faster and less expensive, but it is binding and you waive a lot of significant rights, those of which are, again, too broad to cover in this webinar. I do have webinars I will try to list below that discuss the difference between arbitration and mediation, as well as the rights and benefits that you have and detriments also to those processes. Again, there should be links below. But consider these alternate dispute resolution options: mediation, arbitration, collaborative. It's usually called collaborative divorces, but you could do collaborative processes in anything. Again, a very complex process, more so than both mediation and arbitration. But again, too broad to go through here. And again, I don't want to sound like a broken record, but I do have webinars on my YouTube page and website that you can get more information on. As I promised, some bonus tips. First one, building a support network for divorced dads. One, your friends and family are the first and most important. Surround yourself with a strong support system of loved ones who can provide emotional, practical, and social support. Parenting groups. Connect with other divorced dads in your community to share experiences, advice, and resources. Excuse me. The Micklin Law Group has a monthly online support group for divorced fathers. You can go to my website, micklinlawgroup.com, and find out the next day and try to register. There are also many other online and in-person support groups, depending on where you're living. If you want something in person, the ones online are growing probably every day. All of them are good. Again, they're just, similar-minded people going through similar problems in a confidential setting to talk and support one another. Highly recommend them. Professional support. Consider seeking guidance from a therapist or a counselor to help you navigate the emotional challenges of divorce. Even if you're through the divorce and you're now co-parenting, it's always good to have some professional support. Again, therapists, counselors, online sessions are available. If you had a high conflict divorce or even a moderate conflict divorce, that conflict is not likely to terminate entirely when your divorce is over. And even if it does, it may take some time. So having support, again, professional and personal, is always a good thing. There's usually very little harm that will come to anybody from having these resources at their fingertips. Bonus tip 2, navigating legal considerations in New Jersey. Child custody rights. Understand your rights and the legal process for establishing custody and parenting time arrangements. Again, very broad topic. I can't go into great depth. There are, I think, 14 different criteria a court does consider when making or changing a custody agreement or order, guided entirely by the best interest standard. I will link a video below where we discuss the custody process so they get an understanding of what you will go through in the event you are seeking a change of custody or a relocation of custody out of state, anything similar to that. Second, child support. Very important, interrelated to parenting time. You should familiarize yourself with New Jersey support guidelines and your financial obligations. I will also link below a webinar I did on the child support guidelines, how it's calculated, what is and is not included. Essentially speaking, it is really essentially an income analysis and calculation, but there are other guidelines. There are some reasons to deviate from the guidelines. Many families have an household income that exceeds the guidelines, so there's high income addition that needs to be considered. And it's a very complex issue that many people don't recognize. Even a lot of lawyers don't recognize how complex child support issues are. Watch the webinar, familiarize yourself, make sure before you agree or go to court on child support that you understand how it's determined, what your rights are, and what the process for deviation, if necessary, is. Lastly, divorce proceedings. Seek legal counsel to navigate the complexities of the divorce process and protect your interests. I don't say this because I am a divorce attorney. When I got divorced, I had a lawyer. You want somebody not just for the knowledge of the process, but somebody who's independent, somebody who's objective, and somebody who's hopefully emotionally more stable than you will be in the process. It is a very taxing, very emotional, very expensive process. Having the support of the types of people that I referenced to this will help you a great deal. None as much as a good lawyer will, because he or she will know both what you will experience in the process and hopefully what you can expect to receive and encounter after the process. As I said, your conflict doesn't necessarily end there, so you need to have good guidance through the process and somebody you can call upon after the process. Good divorce attorney is that person. Conclusion: embracing the journey of smart co-parenting. As a divorced dad in New Jersey, commitment to effective co-parenting is key. By following these steps, you can build a strong, positive relationship with your ex-spouse and prioritize your children's well-being. Embrace this journey with resilience and focus on creating a brighter future for you and your family. I hope this information helps you. If you have any interest in contacting us, you can contact me, Attorney Brad Micklin. Our website, again, on the screen is Micklin Law Group, MICKLINLAWGRUP. Our phone number, 973-562-0100, and our YouTube page, Brad Michael Micklin. If you haven't been watching this on YouTube, please give a like and share this video. It helps promote it to other people. It will be, others will get exposure and the information. Try to help as many as I can with this information. I do also recommend you go to my website and YouTube for other videos. As I mentioned, I will do my best to link the ones related to this down below, but my YouTube and website are very robust with webinars and blog posts on every topic that men and fathers will encounter, both in divorce and in family law in New Jersey. Certainly hope that they help you, and watch as many as you can. Lastly, legal disclaimer for information for the information on this website. I will not take your time to read this and bore you with it, but I do recommend that you read it just so you understand the limitations of this information. Excuse me. And understand how to best utilize it. With that, I thank you for attending. I certainly hope this information helps you. If you want to scroll back to the beginning, to the QR code and schedule a time that we can meet and discuss your issue, certainly feel free to. Otherwise, I wish you the best of luck.